Welcome back. Before we get into the final panel, I would like to introduce Commissioner Hester Peirce, who has served on the commission since 2018. Commissioner Peirce regrets that she is not able to join us today in person, but she has graciously recorded her remarks on video for us to present to you. Thank you.
I'm grateful for the chance to be part of today's conference, albeit only a virtual part. Thank you to Dave Sanchez and the Office of Municipal Securities for the important work you do, including outreach events like this conference. Convening experts and people with firsthand knowledge is a good way to work through difficult issues. Roundtables like those that make up today's agenda are a tool that we should employ to think through the many complicated and consequential issues on the Commission's agenda. To all the panelists, thank you for taking part in the conference, and to those watching, thank you for your interest. The views that I will share with you are my own and not necessarily those of the SEC or my fellow commissioners. I was thinking back recently to running cross country in 9th grade. I used to ride my bike over to Forest Hill Park in suburban Cleveland, Ohio, where my team practiced. John D. Rockefeller Jr. gave the 235-acre site of his family's former summer home for use as a park 85 years ago. Except for one dastardly hill, the beautiful park was a wonderful place to run. My 9th grade self was unaware of the interesting history of the place, but as I looked into that history recently, I noticed a theme: municipal securities. When Rockefeller donated it, Forest Hill Park became part of a larger park system, which, according to one source, was spurred by a bond issue in 1916. 50 years later, another bond issuance funded the construction of a community center at one end of Forest Hill Park, where my brother played hockey. And 30 years after that, another bond issuance spurred, in the words of one observer, a bitter, bruising political battle in which historic preservationists argued that the expansion would destroy the Rockefeller legacy. The municipal bonds showed up with just a bit of historical digging reminded me how municipal securities intertwine with our daily lives, how varied are the contributions they make to our lives, and thus how careful we must be in overseeing the municipal securities markets. Bearing this context in mind, I will spend a few minutes discussing data standardization under the Federal Data Transparency Act and in connection with environmental, social, and governance issues. In both cases, an insistence on standardization can obscure real differences across municipal issuers. Given that this disclosure conference is the first since the passage of the FDTA, let me start there. While I appreciate the great value of structured data to securities analysis, I have had doubts about imposing uniform data standards, which invariably require the use of regulator-specified technologies. Congress made clear in the FDTA, however, that it expects the Commission and other financial regulators to require the use of structured data in financial reporting, including with respect to municipal securities, for information submitted to the Municipal Securities Rulemaking Board. I look forward to engaging during the implementation process with market participants, particularly with municipal issuers and investors. Their participation in the process will be crucial to its success. The unique characteristics of the municipal bond market will require us to consider carefully how the structured data mandate should apply. After all, if the costs of a public municipal bond offering get too high, municipal issuers can raise funds in ways other than selling bonds, such as through the private markets or bank financing. Moreover, because the FDTA empowers the Commission to require structured data only with respect to, quote, information submitted to the MSRB, our implementation of structured data requirements inadvertently could deprive investors of information if issuers reduce their voluntary disclosures because the expense of tagging these disclosures proves to be too high. Although broad, the statutory mandate expressly reserves the Commission's ability to tailor requirements, and we should use that authority to get the balance right. To do so, we need more than just enthusiastic hand-waving about the general benefit of increased transparency. We need a frank discussion grounded in the municipal market's unique qualities about what concrete benefits we expect structured data to produce. You need to understand what structured data will make possible that is not possible now, and how these new possibilities will advance the quality of these disclosures in ways that benefit our markets and investors. For example, if a key benefit of structured data is in empowering analysts to aggregate data across issuers, how does that aggregation benefit participants in this specific market? Do municipal issuers face unique costs in structuring their data? Are there tools upon which small and infrequent municipal securities issuers could rely to minimize these costs? How can the SEC best assist municipal issuers seeking to standardize their data? Will standardization of data obscure important distinctions across municipal securities or their issuers? Only after we've had this discussion will we be ready to determine how the Commission should tailor the structured data mandate to the municipal market. For example, given the great diversity in sizes and types of municipal issuers, the Commission may determine that the benefits of requiring minimal or that the costs are too high. Similarly, given the nature of the disclosures required under MSRB Rule G32 and Exchange Act Rule 15C212, the Commission may determine that a blanket imposition of the structured data requirement to all information provided to the MSRB will not provide significant benefits to the market. Moreover, the Act applies not only to information provided by municipal issuers, but also presumably to information provided to the MSRB by Commission-regulated market participants, such as broker-dealers and municipal advisors. And the Commission will need to give careful thought to whether structuring this information also makes sense. Of paramount importance as we think about the scope of tailoring FDTA requirements, our focus must be on what investors need and not on data that might be useful for other purposes. The need to focus on investors leads me right to environmental, social, and governance, or ESG issues. Calls for greater consideration of ESG risks by corporate and municipal issuers often come from parties other than investors. The calls for municipal issuers to make ESG risk disclosures often come from non-investors seeking to influence issuer behavior rather than investors seeking to allocate capital and understand financially material information. Many companies and municipalities already make disclosures that are designed for these non-investor audiences, but some interested parties want ESG disclosures, regardless of their financial materiality, to be included in securities disclosures. The MSRB recently dipped its toe into the ESG waters with a request for information on environmental, social, and governance practices in the municipal securities market. The comments in response were telling. The MSRB summarized one common sentiment: regulatory action is premature. Another frequently expressed view was that the MSRB, in issuing a request for information that might be read as suggesting that it has a role in mandating ESG disclosures, had strayed outside of its mandate. It can be tempting for regulators to attempt to brute force ESG disclosures through regulatory mandates, but allowing voluntary efforts to play out is more prudent. Voluntary efforts at helping issuers think through risks that might fall within the ESG bucket may be helpful without impinging on issuers' ability to tell their unique stories. Whether the Commission or the MSRB has anything positive to contribute at this stage seems doubtful. As the Government Finance Officers Association pointed out in its response to the MSRB's request for comment, at this early stage, imposing a uniform reporting standard would not provide meaningful assistance for investors and would cause needless work for issuers. The MSRB also has taken an interest in green bonds and other sustainable designations for municipal securities. Here too, despite the enthusiasm of some investors for such bonds, caution is in order. First, regulators are not well equipped to decide what's sustainable. Even with the technical, economic, and scientific advice that they have, regulatory prognostications about which activities are likely to be most socially beneficial are likely to be flawed. Second, such designations can be very difficult in the municipal securities context. After all, nearly every government action is justified in terms of its public, read social, benefits, And many, if not most, physical infrastructure projects are required to undergo environmental review. Does it therefore follow that every government bond issue should qualify for a high S rating? If not, who is in a position to make that determination? Can an environmental rating be awarded prior to a successful environmental impact review, or would it be appropriate to assign a low E rating even if that review is positive? Is a bond issuance that funds the expansion of my beloved Forest Hill Park by nature, no pun intended, sustainable, or is it not sustainable because, in the words of one opponent, it would desecrate the park and constitute the worst example of park planning I've ever seen? Third, a sustainability taxonomy for municipal securities will end up driving private capital flows, even if the taxonomy is not, even if that taxonomy is fundamentally flawed, it will drive capital flows in the direction of those fundamental flaws. The decisions embedded in the taxonomy will be reflected in lower financing costs for certain types of infrastructure projects, higher costs for others. And some municipal issuers might be disadvantaged because the taxonomy doesn't adequately capture the benefits of the project being funded. Thank you for your time today. On my next run through Forest Hill Park, I will surely think of Rockefeller's generous gift and the municipal bond offerings that have enabled multiple generations to enjoy that gift. May the rest of your conference this afternoon be as enjoyable as a run in the park. Thank you.
We thank Commissioner Peirce for those remarks. I would now like to introduce our final panel of the day, which will cover current disclosure topics in the municipal securities market. It will be moderated by Dave Sanchez, the director of our office, and will include 4 panelists who I will introduce now. The first is Leanne Gaunt, who joined the SEC in 2000 and was named chief of the Enforcement Division's Public Finance Abuse Unit in 2013. This unit investigates potential violations of the federal securities laws in the area of public finance, including municipal securities. Hillary Phelps. Hillary Phelps is a partner and member of Chapman's National Public Finance Department, where she serves as bond counsel, disclosure counsel, and underwriting counsel for a variety of tax-exempt and taxable financings throughout the country. Previously, Hillary had served as senior counsel in the SEC's OMS. Brian Riley. Brian is a senior municipal advisor and managing director at Elhers. As a member of their management team, he presently leads a team of 13 registered municipal advisors and is also the president of Elhers Investment Partners, a federally registered investment advisor with more than $2 billion in assets under management. Jody Smith. Jody is a shareholder in the Public Finance Group at Maynard in Birmingham, Alabama, and he has over 25 years of experience and focuses on tax-advantaged finance and securities transactions and on infrastructure transactions. Jody now serves as the president of the National Association of Bond Lawyers. Without further ado, Dave, thank you.
Thank you very much, Adam. So in today's last session, we're going to kind of hit you guys with a smorgasbord lightning round style, talking about various current disclosure topics. We're going to start out with municipal advisor responsibilities for disclosure. Then we're going to talk about the limited offering exemption under Exchange Act Rule 15C212. We're going to talk about a governing body of an issuer's reliance on professional staff with respect to issuer's finances. Talk about conduit issuers' responsibilities for disclosure. And if we have time, a couple of other topics. So when folks are thinking about potential questions at the end of the day, you can cover any of these topics, but also any other current disclosure topics you think might be of interest to the commission. So just starting with the first topic that I mentioned, which is municipal advisory responsibilities for disclosure. I'm just going to start out with an open question, which is, and this is going to go, purely at random to our only municipal advisor on the panel. In your view, Brian, How does the municipal advisor's role as a fiduciary relate to its disclosure responsibilities? In particular, how would you distinguish between a municipal advisor's fiduciary duty and disclosure responsibilities as contemplated by an engagement letter?
It was kind of you to put me first in a room full of primarily lawyers, I suspect. So at least you can hold your attention to the end and listen to the rest of the lawyers as the Q&A continues. I would say it's probably best for me to give a little sense as to the lens I view this through, which is primarily relates to our practice. And that's, as an advisory firm, we work with our issuers on, I'd say, a little over, not this year, but on a regular basis, about 300 municipal security offerings a year. I'd say anywhere from 80 to 85% of those are sold through competitive underwriting. In almost all of those cases, we are the party responsible for preparing the official statement. The rest of those are largely negotiated, and in many of those occasions, we are also preparing the official statement. It does not mean that there's not underwriters counsel involved, working directly as a part of the team. And certainly as a part of our competitive issues and a bulk of the negotiated issues, there's also disclosure counsel. I'd say about a third of the entirety, there is disclosure counsel on the transaction. So I'd also point out some of the recent guidance that has been released by the commission, largely as relates to the obligations of municipal advisors in a competitive sale, which I think looks back actually to some prior guidance dating back into the 90s. But in those particular circumstances, it really speaks to what primarily the diligence obligations of the underwriter are in a securities offering, but then states in a competitive transaction, the issuer has its own obligations in all circumstances, but the party that's largely responsible for producing the offering document then steps into, at least some degree, the diligence obligations of the underwriter, which makes logical sense in a big regard. And maybe I'll also ask too, Dave, what's the statute of limitations on securities law violations?
That's Leanne's question.
Yeah. Whoever answers it, I'll appreciate it. But Ehlers as a business has been around for almost 70 years, and so the diligence. If you go back to, I'd say, even the 60s, I've looked at some of the official statements that we prepared, really consisted of a tour of the local jurisdiction and taking pictures of the nicest house in that city and then describing how beautiful of a place it was to live. So I'm not sure that meets the standards of today's environment. So we do take this seriously. And so from our perspective, stepping into that role and understanding what our obligations are, before I hit the fiduciary duty, I'd actually probably start with the duty of care, Dave, and think about it from what our clients need, and they are going to rely on us to help them understand what their own diligence obligations are with respect to a primary offering of municipal securities. So it's really an intimate part of what we would do on a day-to-day basis, even setting aside the notion that we'd be preparing the offering document. If you think about it from the fiduciary standard, you start with the notion that you're going to put their interests above your own. I mean, that's pretty much the first thing that comes into your mind. But ultimately, it boils down to, as you stated, the nature of your engagement. You have to do what it is you say you're going to do. So if you provide an engagement letter with a scope of work that states in no uncertain terms that you are responsible as a firm for preparing the offering document, you had better have, I would hope, a robust system of policies and procedures in place to demonstrate the diligence that you've undertaken. Furthermore, as I stated under the duty of care, the issuer, your client, is going to assume that you're going to help them out, at least to some degree, with their diligence obligations. And I would even extend that to a negotiated offering. A lot of what we do in those transactions is really assist the issuer with the diligence requirements of the underwriter and its counsel, and help really kind of be the auxiliary staff in that regard to the greatest degree we can. So from our perspective, we do have what I would call a very robust system of policies and procedures, which also brings into play supervisory structure. So for those things that kind of fall out of the framework from our more day-to-day, perhaps sometimes mundane life, we do a lot of general obligation debt, essential purpose utility revenue obligations. For those circumstances where we don't have prior practice preparing an offering document for a particular credit or structure, we shouldn't be doing that. You can't hold yourself out to be something you are not. So even if you tell somebody, we'll prepare the offering document, if you have no history of doing so as a business or as an individual, and you specifically don't have any prior experience with that particular type of obligation, the structure, the credit, et cetera, you really should not be stepping into that role. I would also say too, in that regard, most of our clients do not have policies and procedures regarding participation in a primary offering of securities. So again, we're looking at it from, we're an extension of them, we're representing them throughout the transaction. As the preparer of the document, we really need to demonstrate to potentially an examiner that we've done our diligence, but also that the issuer can demonstrate that they've conducted the diligence necessary to put out a securities offering document.
So you mentioned a couple of things that were a little unique. So obviously you do mostly competitive sales, and then you also mentioned that you have engagement letters in place. But how would you feel about a situation where your engagement letter, or some of your colleagues, where engagement letters aren't necessarily clear, but also very interesting what you mentioned was that issuers will often push you to help, even if your engagement letter may not say that you're helping with disclosure. So how do you think that would affect your responsibilities with respect to disclosure?
I think it should almost be assumed that circumstances are going to change. From our practice, I'm trying to be practical in terms of how I speak about this. I can't really think of an occasion where we would absolutely disclaim any responsibility for assisting the issuer with preparation of the official statement. Even if we're not the preparer of record, they're going to look to us to assist them in crafting some of the language. Certainly, at the outset, you may state one thing, but that may evolve over time. I think we've all been involved in transactions that really kind of change shape and form due to a number of situations, whether it be circumstances of the issuer, market circumstances, et cetera. If you change your role and the nature of the engagement changes, you should be amending your scope of work so that it properly identifies in what capacity will you be participating in preparation of the offering document. If there are too many, there are certain things you can't disclaim just because you state it, in the official statement. I mean, if you are functionally helping along the way, and there is obviously record of that, what you're doing in practice is not mirroring your scope of work. But in any event, you should be amending, from our perspective, your scope of engagement to reflect what you are providing, and also so that your duties align with what you stated in your client agreement.
I don't know, Jody, Hillary, Leanne, if you have any thoughts about what was mentioned earlier.
I'm sure there's some in the audience and perhaps online as well that are saying, hold on, I thought lawyers drafted official statements. Talk a little bit about, and I think there's variability from region to region about who sort of takes the pen on offering documents. Talk a little bit about, Brian, you mentioned that Disclosure Council is involved in some of your deals where y'all are drafting the offering document. What role does Disclosure Council play in those deals?
So Disclosure Council is typically going to engage in their own diligence. We become, to some degree, a part of that on behalf of the issuer. We will also participate in the diligence call with Disclosure Council. If there is not Disclosure Council, we will hold a diligence call. It won't mirror that exactly because we're not lawyers, but we're trying to at least put in place a structure by which the issuer and ourselves as a preparer can demonstrate what's occurred to best ensure the representations and the statements made in the official statement. When Disclosure Council is involved, I would say the robustness of the diligence certainly increases. There are certain things that, as we're not attorneys, and so we're not going to hold ourselves out as such. And if things rise to the level of needing legal guidance on whether it be how you craft language around risk factors, things of that nature that are a little more sensitive, I certainly don't want our team venturing into that realm, and it's actually very nice to have the legal team around you that can assist in that regard. They're looking at things that we don't always, review of any litigation that might be outstanding, things of those nature, or giving guidance on if there is, how to potentially speak to any litigation that might be outstanding. At the end, they're certainly going to provide a diligence file and essentially a reliance or 10b5 letter to the issuer for their files as well. We have not, as a firm, gone to the extent of engaging disclosure counsel on our own. We can rely on certain things from the issuer's disclosure counsel, but certainly it's not an attorney-client relationship for the advisory firm.
Are y'all typically asked to give some sort of 10b5 certification with respect to the disclosure y'all prepare? Usually when have been asked to take the pen, I'm also asked to give some sort of 10b5 negative assurance letter in connection with closing. Sort of how does that play out with y'all's role as the primary drafter?
Yep. From our perspective, no, that is not the case. I also want to characterize it as when we're preparing the documents, I don't want to call everything we do vanilla for the most part, but I thought that was very well said in the last panel. Don't live in a silo, right? Go out to NABL and look at guidance on, crafting disclosure for certain credits. NFMA has white papers or other guidance. There are other transactions in the marketplace that you can certainly go and look at the disclosures that are made. So if you're not in a place where you're kind of on top of your game and regularly reviewing what's in the market, it's probably not an area of your business that you want to do a whole lot with, and maybe just let it sit on the shelf.
I just wanted to add, just because of the general point, I think this is an interesting topic, and I was, I guess surprised to see it on the list, just only because it's something that isn't really talked about a lot. It wasn't something that came up in the context of the municipal advisor rules in the adopting release. It wasn't really, it's not discussed in the MSRB rule G42. And anything that exists with respect to this topic is, pre-MA rule, pre-Dodd-Frank. I think there's a footnote in the 1988 release to this topic. There's a couple enforcement actions, again, that predate the MA rule. So it's just an interesting topic, and I don't know that all municipal advisors are necessarily thinking about it in terms of their liability that exists when they're involved with preparing the offering document.
Is that a warning?
No, it's just a thought that it probably warrants further discussion and maybe some guidance if it is something that's,
I would say the size of our firm lends itself to being able to put in place systems of process at the staff level, rising up to the advisor level. If things are kind of out of the normal character, there's a supervisory structure in place to make certain that we work with our regulated MAs so that they're not operating kind of, I won't say in the shadows, but they're doing things that potentially they shouldn't. Ultimately, that's going to impact our clients, the issuers. It's their disclosure document, even though we're assisting with it. So we want to hold them in the highest regard and make sure that the disclosures that they're setting forth are materially accurate and free of omissions.
That wasn't meant to be like you're going to get in trouble. It was meant to be that I think that it is a topic that warrants potentially some guidance if it is something that's going to, be under the SEC is going to be concerned about it. So, and to guide your obligation.
So Hillary anticipated my next question, which was, one, I'm happy that our panel got the throwback to the oldest SEC Commission guidance of the day to 1988 and a footnote no less. But, is there anything you want to see from us, Brian, or anybody else with respect to municipal advisor rules and disclosure, or, it's okay to say nothing?
Nothing specific to the MA rule. I would only bring up the same things that would probably have been said throughout the course of the day. I'm happy to be surrounded by lawyers all the time, and so we rely on them quite heavily in terms of providing direction on crafting certain statements and just, it's always a team effort, right? And ultimately, we're surrounding the issuer with our advice and guidance and making sure that they're in the proper place. There are always occasions where there's going to be a lack of guidance, and a lot of that revolves around materiality. And so sometimes our role is to kind of rein in the issuer to some degree and try to help them understand if you're saying certain things, you may be committing yourself to continuing to say them for a very long period of time, and perhaps that's not the best approach.
Okay, does anyone have any final thoughts on this topic?
I was just curious, how do you go about drafting, Brian? I mean, when I work with younger lawyers, my sort of point is you could draft it freehand from scratch. You could start with a form. You could start from precedent. I'm assuming you are typically starting from some sort of precedent, a comparable GO if you haven't worked with that issuer before, or the last geo deal for them if you have worked with them before?
So we have a template that we would typically use depending upon the credit and potentially the structure, largely the credit. We go through essentially a diligence process with the issuer through, say, a questionnaire. A lot of it is know your client, to be honest. And so if you have a good understanding of your client, who they are, what circumstances they're under, you can help them understand their own risk profile to a large degree. But working off templates, having a to a large degree, rigid, but also sometimes flexible process and a set of policies and procedures. We engage with underwriters regularly. I mean, we're in the market nearly on average every day. And so listening to what the desks have to say, it might come up later too through our Q&A, but we also have a dissemination agent practice, and we have over 1,000 clients in that regard. So the things related to, say, look backs to compliance with CDAs, we have staff that are extremely capable in that regard, understand the rules, and so we can help look back at compliance aspects, contemplate potential language if we need guidance. Obviously, we will get the attorneys involved if it's something a little bit out of the ordinary or it's at least questionable. Invariably, you will get a compliance department at a dealer who will tell their underwriting desk, if you want to buy this deal, we see this, there's a little hair on the continuing disclosure, and if you want to purchase it, you need to contact the MA that's doing the competitive sale and tell them that we see this, if we are the winning bid, we want this language in there, and if not, then we're out.
Can I ask one last question?
Absolutely.
And more for Leanne. You mentioned your engagement letter and sort of scope of services. I mean, I think there, amongst lawyers, I mean, typically with bond counsel may have certain sections of an offering document that it takes ownership of. I mean, that's permissible, Leanne, right? I mean, if you've got a clearly defined engagement letter that says we're not doing disclosure, because in my experience, the MAs that I typically deal with in the markets I'm working in, they sort of like Monty Python and the Holy Grail, they run away from disclosure. So, but it is permissible for those MAs to say, we're not taking a role in disclosure.
Yeah, I mean, I think at least our experience has been that some contracts do try to carve out, what we're going to do. And I would emphasize, I think Brian's point is a really good one, that documenting the engagement in a timely fashion. I mean, one thing I think we're seeing, as an aside, is some MAs aren't doing that in a timely fashion. They're doing it kind of halfway through the engagement or what have you, and that's just a real mess. There's really no reason for it. So, in addition to documenting it in a timely fashion, documenting it clearly, and then God forbid you find yourself in an enforcement environment, we're obviously going to be looking at the engagement letter, but that would not be the end of the story. And I think that goes a little bit maybe to Dave's point that, to the extent you've carved it out or you've somehow, disclaimed that, that any intent to provide advice on disclosure, we will then look to see whether you actually did. Because I think that pulled you back into the fiduciary duty, and so it's probably the starting place, and Brian's point is well taken. Either keep those parameters and respect them, or update your agreement.
And I should probably supplement with, when it comes to things like the tax matters section, we're relying on bond counsel to provide that language. That's in their purview. Security largely is developed through the statutory language as well on many occasions, and again, in some of the authorization and the proceedings that occur before issuance and sale of the transaction. Some of those things, we rely on the bond attorneys to provide us with proper language, allow them to review and comment. They can review and comment on the whole thing. And to whatever degree, we'll certainly take their input, but we are working with the other finance team members to incorporate their bodies of expertise into the offering document where that is not in our wheelhouse.
So before we move on to the next topic, I just want to ask one more follow-up question from a factual perspective and keep you on the hot seat, Brian. Do you notice a difference in municipal advisor participation in primary market disclosure versus secondary market disclosure? For example, you said there's an expectation for you to be involved while producing a primary offering document. Do you have that same expectation with respect to secondary market disclosure? And what do you see generally in the market?
I suppose that'd be the difference between like an endangered species and an extinct species. We're probably unique to some degree in the amount of offering documents we prepare. I know there are others, and I thought the point was well made. It is geographical, and it's just historical practice, right? And so, I've been doing this for about 20 years. The firm was doing that, and in that market, that's commonplace in the markets we operate, other than a handful of states where we don't, and we don't draft the documents. As far as secondary disclosure, again, it is to some degree geographic, and there's been a very consistent practice over time in the markets where we operate that the municipal advisors have also had dissemination agent practices. Now, that's more of a ministerial duty from my perspective, in that you have a set of requirements set out in the CDA. We're really helping the issuer comply, right? We're intaking information from them, putting it into the format that is required of the EMA system and posting it out there. Periodically, there was a big discussion on voluntary disclosures. We'll have our clients ask us about those things. My first response is typically, let's get the lawyers on the phone to talk through this and hash through it. But a lot of that has to do with thresholds of materiality by and large, but we're not, the end-all be-all in that regard. So you definitely see fewer municipal advisors working in the context of continuing disclosure as you do in primary disclosure.
Great. Okay, so we're going to switch topics.
Can I say just one thing, Dave,
yeah,
about
absolutely.
that? Yeah, I was just going to say that it's with respect to the secondary market disclosure, that I think that there's even more, there's a greater chance of something going wrong there with respect to those disclosures, because you have less lawyers at the table nitpicking everything. And so, with voluntary disclosures, of course, there's some that are very route. You notify of a change in rating or a change in the trustee. But if you have something where you're presenting financial information or budgetary information or something like that, it's not necessarily enough just to throw that up on Emma. You may need to be asking some questions about, since this is as of this date, is there anything that's happened since as of that date? Is there anything in the future that could make this misleading just by throwing it up on Emma? So I think in some cases, to your point, like, calling the lawyers, it can be useful where it's things that are maybe, it's not as straightforward necessarily to avoid any issuer liability for their secondary market disclosures.
Okay. So recently, the Division of Enforcement has brought actions against multiple dealers for violating Exchange Act Rule 15C212's limited offering exemption. I'm going to first have Leanne talk a little bit about those cases, then we'll have a little bit of discussion about its impact on the market.
Thanks, Dave. And actually, Chair Gensler referenced these in his remarks at the outset. So starting last September, the Commission took enforcement action against 6 underwriters for violating Exchange Act Rule 15C212. Those cases involve the misuse of what is commonly referred to as the limited offering exemption. And maybe everybody here knows what that is, but I actually didn't know what it was until not that long ago. And for the benefit of folks who don't, at highest level, everybody here knows obviously municipal issuers are exempt from the standard registration and reporting provisions of the securities laws, and that 15C212 creates similar reporting requirements by indirectly imposing disclosure requirements on underwriters. Directly on underwriters to indirectly impose them on issuers. Rule 15C212's focus is on offerings that involve generally the offerings to the general public and securities that are likely to be actively traded on the secondary market. And so there is a sense that some offerings are not going to be offered to the general public and maybe aren't going to be actively traded. And so there's an exemption written into 15C212 called the limited offering exemption for offerings which are going to be offered to a smaller number of people, where they're intended to be held and not actively traded in the secondary market. If you will bear with me, I will read you the requirements of that rule. So the offering exemption applies to primary offerings of municipal securities if the offerings are sold in authorized denominations of $100,000 or more, so that's a pretty high minimum denom, and to no more than 35 persons, so that's your limited group of purchasers, not a general public offering, each of the 35, each of whom the underwriter reasonably believes has 2 qualities. 1, has such knowledge and experience in financial and business matters that it is capable of evaluating the merits and risks of the prospective investment, so a sense that the purchaser is sophisticated. And 2 is not purchasing from more than one account or with a view to distributing the securities. So purchasing them essentially for their own account and to hold them and not to resell them. So the commission, so in our enforcement actions, we found that the underwriters at issue, the 6 underwriters at issue, had used the limited offering exemption, but that they had not taken steps to form that reasonable belief that the securities were being sold to that specific limited group of investors. Our cases focused on sales to broker-dealers, who typically are buying on behalf of somebody else and therefore are going to be reselling, and to investment advisors with separately managed accounts, and those, again, are typically going to be sold into separately managed accounts. And so in each case, we found that the underwriters had sold the bonds to those 2 groups of people, 2 groups of purchasers, and did not inquire or otherwise determine if the broker-dealers or the investment advisors were purchasing the securities for their own account, or whether they were purchasing them from more than one account or for distribution. They also failed to ascertain for whom the broker-dealers and investment advisors were purchasing the securities. So who were the customers or the clients who were going to be the downstream purchasers. Because they didn't make that inquiry, they were unable to form a reasonable belief that the broker-dealers and investment advisors were purchasing the securities for investors who possessed the necessary knowledge and experience to evaluate the investments. And so the commission found that in those 6 firms were therefore not, those firms were not entitled to rely on the exemption, and the investors should have been provided with the disclosure documents that are required by 15C212, and that the firms therefore violated Rule 15C212. So we've brought six cases, 5 of them settled in administrative proceedings, in which each of the firms agreed to censures, cease and desist orders, disgorgement, and prejudgment interest, and civil penalties. And then 1 matter is in litigation and is pending in the Southern District of New York.
So, and I'll put this question to Hillary first. In your view, what has been the impact of these enforcement actions on disclosure practices, especially as it relates to how firms monitor compliance with the limited offerings exemption after these actions?
Yeah, I tend to think of this both in terms of like my role as underwriters counsel and as bond counsel. With respect to underwriters counsel, so I think these cases were really looking at a type of transaction where honestly, I don't know that there were underwriters counsel involved, or nor would they need to have been. I don't think that there were investor letters. It's kind of different than the typical limited offering that I work on, where there is often some disclosure, maybe some form of a continuing disclosure agreement, and there is a very tight investor letter. I will say that in talking to some of my clients, I understand that their policies and procedures internally have definitely tightened up with respect to this matter. We're seeing more kind of involvement of internal counsel and oversight with these types of deals, kind of very similar kind of reaction, like kind of post MCDC, where the SEC is looking very carefully at a very specific issue. I'll say that the transactions I work on, as I noted, often have some kind of offering document. So I think that we're going to see a move to let's just fully comply with 15C212 in terms of the offering document and the continuing disclosure. We're already kind of 3/4 of the way there anyway. For various reasons, we have not historically complied, and we haven't had to comply because we have, got an investor letter with all the representations in there. So I think we could see some of that. From kind of looking at from the other side of things, which is an interesting perspective because, of course, 15C212 doesn't apply directly to issuers of municipal securities. I do think that there's a little bit of consternation from the issuer community and their counsel with respect to these cases, to the extent that they're selling securities where their investor letters have not been obtained, but there has been a representation made by the underwriter of the bonds that they are going to meet the requirements of 15C212 with respect to, determining that the investors are sophisticated and they're going to hold them for their own account. And so, issuers are thinking, wait a second, should I really be having my securities out in the market with limited disclosure that could end up potentially in the hands of someone they're not supposed to end up in? Even though that's really it's not their responsibility, at the same time, I think there is some nervousness that they could get, pulled into something, or they could be looked unfavorably in the market if, something happened, if they ended up in the wrong hands. So I think in that sense, I think there will be at least a minimum of like a hard requirement of an investor letter and those types of deals going forward. And I would imagine too that a lot of the banks are requiring them anyway now. But so there's a lot going on and kind of it's a tricky issue to think about as a lawyer in terms of there's certain things I can do to help my clients ensure that they're meeting the requirements of 15C2 of the limited offering exemption, but there's certain things internally that are happening with respect to monitoring and making sure that they're identifying these investors as sophisticated. We can, we'll get them to sign off on the letter, but are there certain additional steps that need to be taken to kind of, solidify that expectation that they are who they say they are?
Yeah, Leanne, were there investment letters on any of these that were settled, or?
So I'm going to be limited. I'm going to be limited in what I can say because one of the matters is still in litigation. But the public documents make it clear that the underwriters took no steps, from which you can draw what inference you'd like.
And I guess the other thing too, kind of Jody talking about investor, that is not there's nowhere that says anywhere in any of the SEC guidance that an investor letter is that you need one or that is enough to get you where you need to be. I think it's just been historically seen as a good tool to create a paper trail and to get those representations. But I do think that their questions are raised, because there are kind of certain statements made in the settlements that there might further investigation may need to be made beyond just an investment letter, which,
Yeah, that's sort of where I was going.
Right.
Is it sufficient to get an investment letter?
I'm not in a position to answer hypothetical, but all I can really say is that in these situations where no inquiry was made, and an investor letter I think would be a kind of an inquiry, that is insufficient, and so. But I do think Hillary's point is a good one. I mean, I am aware of a thing called investor letters, and I'm aware of other kinds of methods that firms use. But there is. I don't think we're saying that there is one way to do it. I think the reasonable belief is our standard here. It's written right into the rule, and so I think it behooves underwriters to think about what is the basis for my reasonable belief, and I think some policies and procedures around that to make it clear what you've done, that you've been reasonable and diligent in forming that belief would be beneficial.
And so, for example, in the public documents, you saw some references to some of the bonds were sold to broker-dealer firms. So if you have an investor letter, even from a broker-dealer firm, I mean, Hillary, would you ask further questions about that?
I would, yes. I mean, I think that's, you get very few actual details in the settlements, and when you see broker-dealer, that was problematic. I would want to know where they're, if there are, just gets further reassurances that they're not going to be. I mean, and the thing, it's tricky too, because you are allowed to trade these securities. Things happen. And so, because there was some discussion about, should we be looking at Emma to see what happens to these securities after they're sold, and how many days is too few days to not satisfy the requirement? And as we know in our economy, things change very quickly in our market. So there could be a very valid reason for why these securities were sold very quickly. So that's a kind of a tricky proposition. I guess if you see a real pattern of a specific investor, over time, really, then maybe that's selling them right away. Maybe that's an indication that you can't make that reasonable determination. But I think that's a hard question. But with respect to the broker-dealer question, yes, I would ask for further information.
So, Hillary, you had mentioned, issuer concern about the enforcement action, and just want to see if folks have noticed these enforcement actions having impacts on any other non-dealer participants in the market, either issuers, investors, or any other party.
Yeah, I kind of alluded to that in my earlier answer, but I do think that, as I said, again, we firmly believe and know for a fact that 15C212 does not directly apply to issuers. That being said, an issuer does not want, a limited disclosure or no disclosure out there with respect to a security that ends up in the wrong hands. And so they don't want to get brought into these, a bad situation. So I think that they're just thinking more carefully about this than maybe they have in the past, given these enforcement actions. I think at a minimum, as I said, an investor letter, in some cases, maybe it's, It just depends on how conservative your bond counsel is. You know, we're actually, you know, for example, we have to, if you're not going to give us an investor letter, then we need full disclosure. We need a full continuing disclosure agreement, or if there's something in between. But I think again, I think it really depends on who your counsel is and kind of how they feel about it as part of it.
As somebody representing issuers, you know, what about the traveling letters? Is that maybe more appropriate where, you know, transactionally you need to continue to ensure? Of course, any of my clients would be disappointed and probably not too happy that their name is out there in the sphere, even though it's really at no fault of their own. But would something like that assist with that type of, say, reputational damage?
I think it would. I just think that I historically have noted that investors are very reluctant to sign traveling letters. They just don't want the responsibility of having to get them signed going forward, and to have to track that over the life of the bonds is kind of an undertaking. But I think, yes, that could be a solution. It's just, it's a tricky one.
I guess just stepping back, I mean, most of these securities that we're talking about, there'll be some exceptions, but most of these are exempt securities under the 33 Act. So, but for the limitation that, you know, there has to be an expectation to hold these securities, I mean, they could be traded in the market without some sort of transaction exemption under Section 4 of the 33 Act.
That's exactly right. I mean, there's no restriction on them. They're not. I mean, the assessment about whether they're being purchased by someone with an intent to sell is an assessment that's made at the time of the sale. And I think Hillary is exactly right there. That's the concern. You know, you're not compelled to hold them to maturity. And in certain cases, I'm sure people do sell them. But the point is, we're trying to avoid an indirect general distribution, kind of undermining the concept that this is a limited offering intended to be for a small number of people. And that's why they're getting the benefit of less no disclosure. I
will say, like, instead of I was just thinking about this, instead of a traveling investor letter, I have seen it, and I've done this, where you draft it, and there's an offering document typically involved in this, where basically the investor agrees that they will not trade them to anyone other than an accredited investor or a QUIB in the future, which is a little bit easier of an ask, because you're not asking them to fill out paperwork. It's just asking them to restrict who they're selling to in the future. So I think that is, you know, that's been received well generally. I mean, I guess some investors might not, you know, they didn't want to agree to it, they just wouldn't buy the bonds. But I have seen that as a way to kind of limit the market of where these bonds head in the future.
I would also say, and just again, if I'm giving my client advice, increasing the minimum denomination size will typically assist in that regard, but you know, inflation's biting into that for sure.
All right, so any final thoughts from the panel on this particular topic? Hillary, you caught me with the last second buzz in on the last one, so no additional thoughts. All right. Now, we've talked about some disclosure responsibilities for municipal advisors, also for broker-dealers. Now we're going to switch to talking about the issue with respect to issuers. And this is the governing body of an issuer's reliance on professional staff with respect to their finances and their disclosure documents. So I was happy earlier today to hear a throwback to the 96 Orange County report. In 1996, the commission issued a report of investigation with respect to the conduct of individual members of the Orange County Board of Supervisors. And at the same time, the commission announced settled actions against the former county treasurer and assistant treasurer, as well as cease and desist proceedings against the county and some related entities. All of this was related to the Orange County bankruptcy in the early 90s. So this Orange County report, the commission issued the report to emphasize the responsibilities under the federal securities laws of individual local government officials who authorize the issuance of municipal securities and related disclosure documents. The report is available on the Office of Municipal Securities website, as well as another number of other forums. It's very easy to find using your favorite search engine. But I think it's helpful to revisit this report, you know, kind of on the theme of what is already out there, what information has the commission already provided that is useful to practitioners. This doesn't foreclose us from providing additional guidance, but what information is already out there that people can use now. And it's important to revisit this report because it includes a number of specific facts as you read through it that I think really provide some additional touch points for practitioners to look at and to help explain why these supervisors in this particular circumstance fell short of fulfilling their responsibilities. But also importantly, the report acknowledges that every municipality's situation is different and doesn't dictate specific ways for similar officials to fulfill their duties. Related to that, in 2007, the director of the Division of Enforcement at that time gave a speech also available on our website and other forums called Lessons Learned from San Diego. Both of these things are very helpful in elucidating what responsibilities are. When I was in private practice, I gave disclosure guidance all the time, and I noticed that a lot of times issuer officials had a very distorted view of what their responsibility might be. The prevailing view was every single person has to read the official statement cover to cover, including financial statements, notes, et cetera. So I'm going to throw this to you, Jody, first. What do you think are the governing bodies' practical responsibilities regarding the preparation and review of disclosure materials?
Sure. Thanks, Dave. And I'm going to start this with some very practical advice, and then maybe we can back up and talk a little bit about how to interpret Orange County and San Diego and other actions. But I mean, there's a very helpful analysis of this in the American Bar Association and the National Association of Bond Lawyers published a publication called Disclosure Roles of Counsel about a decade or so ago. And it had a very helpful, I thought, sort of four-part test here, which was as a public official, and whether that's whether you're talking about somebody in the executive branch, mayor, or you're talking about a member of the governing body, like a city council member. Four questions you can ask yourself. Have we adopted disclosure procedures? And if we have, am I satisfied that such procedures have been reasonably designed to produce accurate and reliable information? Second question, do I have a reasonable basis to have confidence in the integrity and competence of the financing team that has prepared the offering materials? That would be in-house staff, in-house financial staff, in-house counsel, outside counsel, et cetera. Third question, do I know anything that would cause me to question the accuracy of the disclosures or that would indicate that they are misleading? And then fourthly, do I know of any potentially material issues that should be brought to the attention of the financing team or for which I would like further explanation? And revisiting when you look at some of the materials on San Diego, for example, the crux of that enforcement activity related to some pension and retiree health care benefits and just the costs that the city of San Diego was going to face there. And it was pretty well known. And so I guess the enforcement division's view was that it was very known and it was sort of a red flag. It should have been something you should have asked about. When you look at Orange County, it struck me that I know that the enforcement division has brought cases against states, state of New Jersey, state of Kentucky, others before, but I don't think they've ever gone after the governing body of like the state of Kentucky, state of North Carolina. It'd be one thing, governing body, something like the North Carolina General Assembly or the Alabama legislature, very different. The Board of Supervisors, I believe, was the governing body of in Orange County. And it struck me sort of looking back at the Orange County report, Dave, that there seemed to be sort of a mix of legislative responsibilities as well as executive responsibilities with the Orange County Board of Supervisors. And so I guess where I'm going with all this is I think the degree of the responsibility of a governing body member, I think is going to turn a lot on how much control they actually have over the disclosure process. And I know that there have been a number of enforcement actions against executive members of an issuer, whether that is a mayor in the context, I think Allen Park, multiple finance directors, et cetera. And that's where I think often there is where all the action goes on within an issuer in the drafting of disclosure. I mean, and going back to my 4 principles, my view is that if you have comfort that you've put process in place and you know of no red flags, I think it's permissible for a governing body to largely delegate responsibilities for preparation of disclosure to the staff and the professionals that the issuer has hired.
Just quickly to that point, like, so one of the interesting things about Orange County, right, was that the Board of Supervisors had unique information about the risks being taken by the county treasurer. So that's not the case all the time, but it's something to keep in mind. I know in the earlier panel, it was stated that you never know how many people go into producing one number in an official statement. So it was very clear in this particular context, and why I think it's very helpful as guidance, is that this county Board of Supervisors had particular information about this particular risk that other folks in the county would not have had. And then secondly, that they were supposed to be receiving a special monthly report from the treasurer regarding county investments, and they hadn't received it in 3 years. But that didn't, they had not raised the question of why we weren't receiving this report. So those 2 facts were, to me, really helpful and really illustrative of kind of unique things that a governing body might have within their unique structure that would make them want to address that and raise questions that they might otherwise raise.
If I could embellish on that last point you made, Dave, in light of what Jody described in terms of policies and procedures, delegation of authority, it should be a facts and circumstances situation, right? If all of the personnel, the staff that you have delegated authority to all of a sudden turn over, right, and they don't really have the history that would put them in a strong position to provide a reasonable basis for the information, perhaps you want to be a little more involved in that particular transaction. Of course, you're not going to know every detail, but you will have at least demonstrated, hey, I reviewed the document. And through that, maybe you pick out a few things that you just go, this doesn't seem quite right to me. To your point, I haven't seen that information before. How come I haven't? You know, you're just going to start to you're going to have like a mental thought exercise around any questions you may be potentially required to ask in that particular circumstance. So just because, you know, I guess a good point of emphasis is don't be a robot, right? Live in the moment and understand the situation around you.
I was just going to say, and this point has been made on other panels, but a lot of this is rooted in training and just making boards aware of this responsibility. One, that it's not, as kind of to your original point, Dave, that they have to read the document cover to cover, but they do have a responsibility to speak up and say, okay, we're issuing these bonds. What about this piece of litigation that's happening that's not covered by insurance? Like, is that going to affect anything here? Is this, you know, things like that, just to raise questions. But they have to know that they need to raise those questions. And you have very varying levels of sophistication with respect to these matters on boards, particularly with the smaller issuers, which make up the majority of the issuers in our, you know, in our public finance universe, who, you know, they're just, you know, regular people living their lives, and they're volunteering to be on these boards, their school boards or whatever. And so you need to be prompted that this is, you know, you have some responsibility here to speak up. And so I think, you know, and again, but I agree with everything with Jody and what Brian said, that, you know, if you can have you've good confidence in your team, and you've got strong disclosure policies and procedures in place, which should be approved by the board, and they should be aware of them. You should take some comfort in that as a board member.
I guess, as a practical matter, when do we think a governing body member raises that red flag? I mean, most cities are going to have to, it's going to have to go before their city council to approve a deal. Is it in that city council meeting? Maybe they get their materials, pre-council materials, are like, hey, I see we've got this bond deal, you know, on approval for next Tuesday. They raise it with the city attorney raises it with bond counsel. I don't know, what have you seen, Hillary?
I mean, I think it could happen at really any level, and maybe it depends on the sensitivity of the issue. And either there's a mistake has been made, but they don't have, a mistake has been made by the person who did put the disclosure together, they don't want to embarrass them, or maybe it's something that, I mean, I think having it on the public record is always a good thing, you know, to have it out there that I raised this, you know, let's make sure it makes its way into the offering document. So I think it really depends.
Yeah, because in my experience with, you know, take at the state level, you know, it's going to be somebody like the state treasurer, state finance director that's going to be on rating calls, on due diligence calls, things like that. You know, probably unlikely that a member of the Alabama legislature is going to be on a ratings call. And same with, you know, going down to the local level of government, it's typically going to be finance director, mayor, very seldom, in my experience at least, is it going to be city council president or somebody like that, unless. So.
Right.
And those, and I mentioned those are junctures where a lot of these issues often get raised. I mean, as a bond lawyer, I always, if not invited, try to insert myself into the rating call process, just because inevitably I hear something on those calls. You're like, you didn't mention that when we were going through the OS the other day. So,
yeah, I think these questions are much more trickier with the bigger issuers, where the smaller issuers, often the staff has a really good feel for kind of everything that's going on, like in the community, for example, if there's someone moving in or a big taxpayer moving out, they're aware of that. And, you know, maybe, and they may have got notice of it, but received notice of it before anyone on the board has. So, whereas with the big issuers, state level, there's so many complicated issues going on that could affect the issuance of the bonds. It's a much harder question.
So kind of related to that, you know, factual questions, but you mentioned with smaller issuers, the staff might be aware, but do you see an issue with sort of staff delegating responsibility to their attorney or to the municipal advisor? Like, hey, we hired you guys take care of this document, we don't need to worry about it?
yes.
Yes.
And how do you feel about that?
Channel my inner Ben Watkins. That is not okay. I mean, from my perspective, the issuer is, at the end of the day, the issuer is responsible. It's the issuer's document. You can have all the professional advisors in the world. That's great, and you should use them. You know, but it's the issuer's document, and we're going to hold it to a standard of, you know, tying this back to the legal standards in an offering context, a minimum of reasonableness, due care, non-negligence. And so if you haven't acted, if you have acted without due care, or have acted unreasonably, or you have acted negligently, even with all of the assistance of professional advisors, that would be a problem.
And in any sort of professional advisor, I mean, I mentioned, I started my 4 points with, you know, good disclosure policies. I mean, any good disclosure policy, it's even if the lawyer or the FA is the primary drafter of the official statement, your good policies are going to drive you to have conversations about things. You're going to have due diligence questions that are going to raise these sorts of things. So even when there is a lot of delegation of these responsibilities, I mean, it's not being prepared by the professional in a vacuum. There is, hopefully, with good process in place, interaction.
From my perspective, I guess two things would be, throughout the course of an engagement, you know, I'm going to be producing things that really memorialize not just the relationship, but the transaction on behalf of the issuer. And if what happened doesn't reflect that, I probably have a problem somewhere embedded in the paper trail. I think the practical aspect too is even if I have a discussion with an attorney, we come to agreement on, say, a path forward. If I can't go to my client and convey to them my point of view, and they say, yep, that makes sense, thank you for taking care of that, let's do that, probably not doing a very good job in the first place. So, you know, you want them to be able to be informed and make a decision. It's not up to everybody around them. And that's not just a regulatory thing, it's a cultural thing, I would suspect, too, in many of the shops where we all work.
Okay, so kind of moving on to a related point, is with respect to conduit issuers. So a lot of times, obviously, disclosure materials in a conduit offering is mostly related to the third-party conduit borrower. But what are the disclosure responsibilities of conduit issuers? You know, can they just put their stamp on it and forget about it?
They can't just do that. Again, I think the practice in the conduit area, and this was, for those of you, I'm sure most of y'all know what a conduit deal is, but this would be your typical nonprofit healthcare hospital system that issues through a special care facilities authority or something like that. I do believe, again, much of the disclosure is going to turn, the responsibilities, again, are going to turn on control of content, sort of like they do when we were talking about the governing body responsibilities. And the content here, I mean, your issuer is going to have statutory powers to do conduit debt for healthcare issuers or things like that. There's certain things that are clearly within its responsibility, knowing what its state law powers are. But what the healthcare receivables are for a hospital or something like that, the issuer is not going to know that. And I mean, I know we're going to get to it in a minute, but Dave, I mean, I think that they're, with appropriate disclaimers, and I think a number of the enforcement division's actions have sort of reinforced this. I mean, I think that in conduit deals, the conduit borrower is sort of viewed as the party in control of the disclosure. And I think things that can be done to reinforce that would be appropriate disclaimers where the issuer says, all the information in Appendix A about the hospital system came from the hospital system. And, only the information under like the authority section or litigation regarding the issuer section is, has come from us. I mean, that said, I mean, I think that, to my point about it can't just turn the other way. I mean, there's got to be comfort by the conduit issuer that a good job is being done. And I mean, some of the things that I've seen over time that help it get that level of comfort would be maybe knowing that disclosure counsel for the conduit borrowers involved that is looking at that disclosure, being sure that 10b-5 negative assurance is being provided by disclosure counsel, perhaps even being an addressee of that 10b-5 negative assurance. I've seen a number of conduit issuers have different policies as between rated debt and non-rated debt, and sort of ratcheting up the game if it's non-rated debt, including things like increasing the minimum denominations for buyers, limiting the sale to either qualified institutional buyers or credit investors, more sophisticated investors, things like that. So, and just hitting on some of, I mean, looking back at some of the case law on this or some of the enforcement actions. I mean, one particular enforcement action where it seems to me that the Rhode Island Commerce Corporation, the 38 Studios, it was a conduit deal, but I think there was much more state of Rhode Island involvement in the offering than would be typical in like a hospital financing. But a number of the other ones, City of South Miami, the Public Health Trust, you had a Miami-Dade County was the issuer, but the focus in the enforcement action was on the hospital. It was mentioned earlier today, the College of New Rochelle, which that was actually in the secondary, the continuing disclosure area, total focus on the nonprofit college conduit borrower versus I think it was the New Rochelle Industrial Development Authority was the issuer. I think I even had to Google that to find out who the issuer was. Maybe it was mentioned in the enforcement action.
Yeah. I mean, I think there have been many enforcement actions where the respondent or the defendant is the borrower, and very, very few involving the conduit issuer. Yeah.
I don't know, Hillary, if you have any other best practices. Jody, you mentioned a couple in your rundown.
I don't. I agree with what Jody said there. Yeah.
Okay, so anything else on this particular topic with respect to either of the issuer topics we raised? So going once, twice, three times. So we're going to move to the recent Exchange Act rule amendments on financial obligations. In 2019, the Commission amended Exchange Act Rule 15C212 to include additional events that must be reported, including certain financial obligations of the issuer or other obligated person. So Hillary, going to put this one to you first. How have entities applied the concept of materiality in their decision on whether to disclose incurrence of a financial obligation? I know we heard some comment on that earlier today. Any additional thoughts?
Sure. I think just to kind of give another shout out to NABL and GFOA, who did a really, I think, exceptional job when the rule, and OMS too, did when the amendments were finalized and kind of educating the issuer community and the attorneys about the rule and what a financial obligation was. And in turn, a lot of disclosure policies and procedures were updated to, kind of list out like, what is a financial obligation in terms of the types of things that we, as a governmental issuer are authorized to even enter into. I think with respect to materiality, you'll see with some of the bigger issuers, you'll have a threshold written into the policy. Some of the smaller issuers, everything seems to be material sometimes just because of the size of their balance sheet and the things that they are kind of non-material or may not even be a financial obligation, some kind of a lease obligation. So I'll say, I don't get so many questions these days about what is material and what is not. I do think that there are a number of issuers have taken the stance that really we're just going to put everything up on Emma, like every direct placement we enter into, every line of credit. And I think that, a lot of times the bond lawyers are involved in those transactions, and so can kind of give a little reminder that, you should consider whether or not this is a reportable event. And I think that's happened for a number of reasons. One, it's just easy. You have the document. You don't have to summarize it. You can just put the document up onto Emma. I think another reason it's seen as a kind of a credit positive in terms of, or just an investor relations kind of tactic to keep as much information free flowing up on Emma between your investors and you, kind of to the point, the discussion of voluntary disclosures earlier. I also think that, this, MCDC continues in terms of we are on every deal, every, public offering, there is a very intensive continuing disclosure, review of historical continuing disclosure filings. And I don't know that issuers really want to get into it with bankers who say they can see it in their audit, you entered into this, whatever it is, this financial obligation, why didn't you disclose it 2 years ago? And you could say, well, we determined it wasn't material. And sometimes that's, that explanation gets you somewhere, sometimes it doesn't. And so just to avoid that argument or that discussion, it's just easier to put it up on Emma. So I think that there's kind of a number of reasons why, we may see sort of setting aside the materiality discussion in favor of just putting it up on Emma. Of course, there's always some risk to that because every time you put something up on Emma, you are speaking to the market, so you want to make sure that what's going up there is accurate and complete. The question I get a lot though with respect to materiality isn't in terms of the materiality of the financial obligation itself. It's with respect to what terms are material in the agreement, and that is in connection with often banks with a direct placement does not want certain terms put up on Emma for public consumption because they think it's anti-competitive, it's giving away kind of inside baseball. And so actually the adopting release does kind of provide some helpful guidance as to what should go in the notice, but it's always, the question is always not about those things, it's about these other things that are a little bit out of left field. So I find myself having a lot of discussions about, what can be redacted and what cannot be, what can be kept in. So.
Hillary, are you seeing summaries, documents themselves, both? I'm typically seeing just the documents, maybe with a cover sheet.
That's what I typically see too, and I think that's the safest route that we would advise because you could always leave something. I mean, you could do the summary with the full document attached to it, but again, I agree. I have the same experience as you do, Jody.
And so also with respect to sort of putting everything up on Emma, are you seeing distinctions being made between credits as was discussed earlier today, or are you just blasting it out to all your CUSIPs?
I mean, I'm not honestly the one who's typically putting them up, so I think both. I do, sometimes get questions about, this is like a loan that's backed with water revenues or something. Does it need to go up on my GOQ-SIPs? In most circumstances, no. And again, there's some brief discussion of that in the adopting release. That being said, it's sometimes just easier, I think, for people to click the box for all the Q-SIPs and just put it up there. And they're not. I don't think no one's saying that this is material to those outstanding public offerings, but just for ease, it's being blasted out to everyone.
I would say sometimes as well you find it's circumstantial, right? So there may be some states where not only is there a moral obligation with an absence or insufficiency of revenues, but there may be something a little more teeth on it that would almost require you to say levy taxes for an insufficiency. And so, yes, it becomes just let's not think so hard about it sometimes. Let's just get it out and let the market decide what's material. But I do also understand that we are kind of littering Emma with a lot of stuff that's probably not. But it only takes one time for someone to do something that they thought was immaterial, and it winds up someone else's subjective determination indicated that it was.
I think I mentioned this to you, Dave, in our prep call, but when we were, in the middle of the, drafting these amendments back when I worked at the SEC, we had a lot of investors come in and talk to us and asked us to remove the materiality requirement from the amendments. And so we were under, the impression that investors, they want to see everything and they'll sort it out on their own get, work through it. So kind of to my point of a lot of my clients see this as a good investor relations tool. I always am kind of reminded of those conversations where I don't think investors are so concerned about littering Emma. They'll take everything.
But are you also seeing a distinction between whether this is filed between voluntary and specifically under the enumerated categories or just under enumerated category?
I typically see them filed under the enumerated categories. If we determine it's a financial obligation, it would go under one of the enumerated. Well, it's going to be 15. I don't know that I've seen a 16 yet, but personally, but I mean, I've seen them up on Emma because I look periodically because it's interesting. I mean, very nerdily interesting. So, but yeah.
The only other thing I'd add to this topic would be there's probably a bright line distinction between, say, conduit borrowers who are really corporate entities to some degree, even though they may be tax exempt, versus governmental issuers with respect to redaction. And that becomes more of a timeliness issue, whether or not you even can. I mean, you just, if a company just entered into an agreement with a public entity, you could easily make the argument everything in there is in the public domain, and therefore what is the point of attempting to redact anything? There may be some ability to redact things that would be deemed trade secrets. You should have asked for that in advance, I would argue. So you still have the 10-day requirement that you need to comply with, and so giving the opportunity for redaction could put you in peril in that regard. But conduit borrowers probably need to be a little more sensitive just because they are operating most likely like a business, and they want to maintain good business relations with their lenders.
I would say just a practice pointer, banks have are aware that their documents might be going up on Emma, and there often are covenants about the process for posting those on Emma. And so be sure as you work with your issuer clients that you're reading that language and complying with it so as not to have some sort of breach of contract action.
And I would say as the issuer, you have the ability to push back. So you don't have to just take what you're given.
So I have one more question for the panel. So if anyone has any questions and you want to step to the mic, now would be the time to do so. But I'm going to put this next question to the panel. In recent years, forward refundings were attractive to both issuers looking for savings and investors seeking incremental yield in a low-rate environment. Obviously, that's slowed down a little bit. But Jody, what do you think is the most challenging aspect of disclosure and forward refundings?
Sure. And given our limited time, I just want to point out that the National Association of Bond Lawyers is in the process of publishing an FAQs on forwards. And as Dave said, this area has slowed down a bit lately. But I mean, the disclosure issues related to forwards, are a function of the extremely long executory period you have between signing the BPA and actually settlement. And as I'm sure most of you in the audience know, typically you're going to have signing of the BPA, a sort of soft closing and then settlement. And, some of the closing deliverables are delivered at the soft closing. Bonds and the bond opinion typically are delivered at settlement. And then, especially if you've got an extremely long forward period, is what termination rights either bond buyers or underwriters might have under BPAs and other contracts related to the bond purchase agreement and things like that. So I would say that dealing with things that can happen, and they will happen, between the signing of the BPA and the settlement on the bonds, and how you allocate that risk. And I think importantly as well, typically there's going to be very detailed disclosure in the offering document about what termination rights underwriter bond buyers have.
And so, the first panel today was asking for all kinds of things from the commission. So anything that you would like to see in the context of forward refundings that we could say that would be helpful? Yeah, see.
We'll send a letter.
There you go. Good question. Yeah, there's a button to slide. There you go.
Thank you. Again, I work with issuers throughout the state. Recently, I had an MA that was doing the documents, the bond documents, and we had disclosure counsel. What I find in that instance is that not enough folks are paying attention to the documents. And as you said, it's ultimately the responsibility of the issuer, the disclosure. So we had to step in on one occasion and say, look, it's over. We're going to get underwriters counsel to do the documents, because the MA is not always aware of legal activities of the state. The laws may change. The practices in the industry may change. Just there's so much movement. And from a state level perspective, cutting costs by $25,000, I say, on a given transaction is just not worth the increased liability and risk. And one of the reasons we were able to come to that determination was because there was actually information missing until the final document was ready to go out and get signed off. And it just so happens that, the bell went off, and then, we put that in. But the issuer caught it, and we decided we wanted counsel to represent us on our documents. At the same time, we have the issue with smaller governments who are also trying to cut costs, and their financings may be a lot smaller than the state's financing, and they can't afford that incremental cost. And not only can they not afford the incremental cost, but they don't have this stability of personnel to oversee these processes, which is actually, in the state of Oregon, is of great concern to us, because we oversee and manage their debt in terms of serve as a repository for their debt. And so in certain instances, we have to approve their obligations. So it's really an interesting situation for the smaller governments. I definitely think on a state level, there should be no circumstances, except maybe in certain private placements, where the MA is doing the documents. We've put in legislation to try to enforce having local governments use the right professionals, but we can't, it's not enforceable. It's just they get to check a box, right? Did I include an underwriters council? Did I include an MA? And so as the sort of paternal entity that reviews these documents, we end up just checking a box, no real authority to enforce anything. But I do think, I guess that was long-winded. From my perspective, the question is to the MA, do you really think that it's a rational risk to take for you to take on the disclosure responsibilities? I was on the banking side before, and I thought the SEC always had the banking community responsible, but I guess I just wanted to direct that question to the MA.
I'll give you my favorite answer. It depends. In many circumstances,
Sound like a lawyer.
Yeah. In many circumstances, we don't draft the official statement. So, I mean, our clients are very disparate in nature. So we work with communities from 1,000 to over 500,000 in population. And so some of them, what they want to put out into the marketplace in terms of disclosure may not mirror kind of the template that we have. And that's okay. We also don't need to draft the document. We can be a meaningful part of crafting the official statement and provide value without being the preparer of it. There's nothing inherently wrong with that. We do take a risk-based approach. We even, there are clients that we work with, say on general obligation debt, where we're very comfortable being the preparer of that document because we have a high level of knowledge in that space. We have the experience. We have the team sufficient to look out into the universe of comparable transactions and ensure that we're providing a requisite level of disclosure. They may do other things, say more development related, where we don't, and we don't want to be in that position. And so we want to make sure we're conducting business in a fashion with our clients that's representative of our level of expertise and not hold ourselves out to be something we're not. I would never proclaim we happen to be domiciled in, I'm in Minnesota. I would never want to do the official statement for the state of Minnesota or any of its agencies. That is just something that we're not equipped for. In other circumstances, I feel very confident in our team and the level of diligence that we undertake and our ability to prepare a document that is accepted by not just the underwriting community and the investor community, but would meet all of the disclosure requirements and regulations that we all generally have to live and abide by.
Thank you. So any final thoughts from anyone on the panel?
Thanks for the invitation. This has been great. I think that the whole day's been fantastic to be back together in person and talk about all these issues. Thanks for organizing this day.
Thank you. And so that concludes our last panel. I want to thank all our panelists today and the folks in the audience for interesting discussion all day long. If the folks up here can bear with me for a second, I'm just going to recap a little bit of the day. Was very happy this morning to hear continued embrace of voluntary disclosure by the market and all the suggestions for practical improvements as well as additional commission guidance. I think we are very invested and have been happy to see the improvements in voluntary disclosure, investors and issuers kind of coming together on what they want. And I think that's been very helpful for the market and has kind of averted the need for more prescriptive regulation in this market. So I think that's been helpful and happy to see that kind of move along. With respect to the FDTA, we realize that there are a lot of issues to consider. Today was, some of the issues that we need to consider, but there are a lot of other viewpoints to hear, and we encourage significant feedback from the market throughout the process. Some folks earlier today were asking how their voices can be heard, and the answer is for you to reach out directly to our office and request a meeting. OMS is tasked with drafting the municipal market provisions, and we enthusiastically welcome input. So please reach out to us. Don't be shy. Everyone does have a seat at the table. And then also really encouraged in the last panel to see some very fast evolution of the understanding in the muni market on ESG and cyber issues, spurred on by the best practices produced by issuers for the market, for fellow issuers and for the market. And also, the kind of laser-like focus on facts and risks as they relate to particular securities and particular offerings. So I want to thank this panel again for covering a wide range of topics so expertly. Before we all depart for the day, I want to once again thank everyone who attended today, both in person and online, as well as all the dedicated folks at the SEC who helped put this conference together. The Office of Municipal Securities continues to be very interested in engaging with market participants with respect to all the issues we raised today, as well as other topics of issues to the municipal market. I know for some of the issues we discussed today, especially the FDTA, this is just the beginning of the discussion. So again, please don't hesitate to reach out to our office if you want to continue the discussion. So this officially wraps up the conference. Thank you all again for your attendance and participation.